Welcome, everyone. Today, we're diving into two crucial topics, asset protection and estate planning. Whether you're focusing on protecting your investments or ensuring your legacy, today's webinar will provide you with essential strategies on securing your financial future. It is top of the hour, and I do want to be respectful of your time, so let's get started. I'm Reneika Lightbourne with Advanta IRA, and I'm honored to welcome attorney Jason Zundel of Anderson Business Advisors. Thank you, Jason, for being our featured speaker today.
Of course, very excited to be here.
You're certainly welcome. Jason will share his expertise on the importance of estate planning, asset protection, and also just his general passion for helping clients on what matters most to them. But before I turn it over, I do want to give you just a general synopsis of what self-direction is and how it works, and of course the process to get started with us at Advanta once you decide to start your self-direction journey. Feel free to type put your questions in the question box. We'll allocate time as we go. After each section, Jason will allocate at least a couple minutes to answer questions that comes in. And then, of course, at the very end, if any remaining questions, we'll get those answered for you as well. Again, my name is Reneika Lightbourne. I'm one of the business development specialists with Advanta since 2019. Prior to joining staff, I'm also an Advanta client as well. So prior to joining staff, I've been self-directing my personal retirement account. So this is something that I personally and professionally advocate. After today's call, if you have specific questions to your scenario, you want to just know more about self-direction, self-directed IRA, solo 401ks, you're welcome to give me a call or send me an email, or certainly visit our website where you can schedule a consultation with myself or one of my colleagues. Just a little disclaimer before we get started. Just know at Advanta IRA, we don't give any tax, legal, or investment advice. All of the information that we'll present today is just for educational purposes. As always, we encourage you to consult with your professional team, whether that includes your attorneys, your CPAs, or financial advisors before making any investment decisions. If self-directed IRA is a new concept for you, I just know it can be a lot of information, but I just want you to take away just 3 simple takeaways, meaning just know that any IRA or former employer plan qualifies to be self-directed. 2, pretty much you get to choose what is it that you want to invest in. You have a long list of investment opportunities that's available to you. And then, of course, knowing that all of the income that's generated from your investment flows back into your IRA. If there's any related expenses, it's paid from the IRA account. So if your IRA bought a rental property, those rental income will flow back into your IRA without any tax liabilities to you. And if there's any expenses, whether it's property taxes or upkeeping that investment, it's paid by the IRA. Just a little history about Advanta and who we are. We've been in business for 21 plus years now as the leading self-directed IRA administrator in the business. While we don't give our clients any tax, legal, investment advice, our team is comprised of attorneys and also a certified IRA service professional. That designation is specific to our industry. We have about $3 billion a little over $3 billion under administration. Our headquarters is in the Tampa Bay area, Clearwater to be specific. Advanta has an office here in Atlanta, which is where I'm based, but we work with clients nationwide. We also have clients that can use IRA funds to invest internationally if you choose to. One of the ways that we separate ourselves is providing you that great concierge style service where our clients have an assigned account manager, someone who's going to be with you for the life of your account when you're ready to make an investment. But also, too, our educational content is second to none, where we have experts and practitioners and professionals like Attorney Zundel coming to just knowledge share with you in terms of different things to be mindful of or opportunities that's out there. This webinar is recorded. It's going to be uploaded onto our YouTube channel and also our video library on our website. You can also certainly continue to go to our website for upcoming future events, or if you have an interest or a suggestion on a topic, feel free to let us know. And then, of course, I would encourage you to check out our blog and also our podcast. My colleague, Alex Perney, does an excellent job with that podcast. So exactly what is a self-directed IRA? Just to keep it really simple, it just means that you as the account owner, you're going to have complete control over the retirement funds. You're going to have complete control over the investment decisions. You get to really diversify outside of the traditional stocks and bonds. Most IRA clients are familiar or accustomed to using IRA funds to invest in real estate. So whether that's a single family home or a multi-unit or a commercial unit, you can certainly use IRA funds to invest in, act as a private lender. And you can invest in vacant land, farm animals, You can invest in oil and gas, pretty much precious metals. The list goes on in terms of what's on the table for you. There's actually only three things the IRS say that you cannot invest in: life insurance and collectibles. Collectibles being anything like antique art, wine stamps, and S corps. But outside of that, you pretty much have a blank canvas in terms of investment opportunities. Why do people choose to self-direct? You may look to self-direct for many different reasons. I'll just touch on three of them. One, it being a new source of capital for you. So for example, instead of taking out a bank loan or tapping into your emergency fund, if you have money that's sitting in an old employer plan like a 401k, or if you have an existing IRA at a brokerage firm, you can elect to move as much or as little as you need to make your investment. If you're a capital raiser, meaning you're looking to allocate funds to buy, let's just say, a commercial unit, you can certainly use retirement funds as a great way to do that, because there's literally trillions, nearly $40 trillion sitting in retirement accounts. And as it comes to self-direction, less than 4% of that is truly self-directed, meaning invested in something outside of stocks and bonds. Another reason as to why someone may choose to self-direct, because of the ups and downs of volatility in the stock market. We can't predict what's going to happen in the market. Something overseas can influence the stock market here. Whereas if you use your retirement funds to diversify into the likes of real estate, which we know is a tangible asset, always going to retain value, then you get to really hedge your bets and diversify. And then, of course, the tax benefits, having those profits, those rents, those dividends flow back into your retirement account, tax deferred or tax free, depending on the type of account that you have. In terms of the different types of accounts that can be self-directed, it's the ones that you're already familiar with. So for individuals, pre-tax, meaning you elect to get a tax break up front, you grow your account over time. Once you reach retirement age, you pay taxes at that point, or at R&B age if you don't take it out at 59 and a half. If it's a Roth account, as long as you've had that Roth account for at least 5 years and you're 59 and a half, which is the IRS retirement age, those distributions in that Roth account will be tax-free. If you are self-employed or you have a side business, or you're 1099, you can certainly look to self-direct a SEP, simple or solo 401k. I know a lot of real estate professionals like the solo 401k. If that's of interest to you, feel free to reach out to me. You have greater flexibility with the solo 401k in terms of it being higher contribution limits and not being subject to UDFI tax related to real estate investments. Some lesser accounts that are just as important that you have the ability to self-direct is a Coverdell educational savings account. So if you have kids or grandkids, you can certainly look to put some funds aside to self-direct and pay for their educational expenses. And then an HSA account. As long as you have a high deductible medical plan, you can look to certainly self-direct those funds. And then any former employer plan, whether it's an old 401k, 403b, or TSP type plan, or any type of pension funds, you can certainly account, you can certainly look to self-direct. The only thing that you need to be mindful of, if it's a current employer and you're not yet 59 and a half, most times they'll tell you, no, you can't move it. So don't be alarmed by that. You can certainly ask them to see if they'll make an exception to allow you to move a portion of those funds. But if it's an old employer plan, you can move it at will. There's no issues there. In terms of funding your account, you have several ways you can do that. If you have an old employer plan, it'll be a direct rollover. You would actually have to initiate that request. You're not taking a personal distribution. You're just moving it from one qualified retirement account to another. We'll walk you through that process in terms of what to tell the other plan administrator. If it's an existing IRA, so let's just say you have an IRA at Fidelity or Charles Schwab, Advanta IRA would actually initiate that request on your behalf. You just need to let us know exactly the amount that you want to move, make sure it's in a cash position, and it'll be a trustee-to-trustee transfer. Again, there's no tax liabilities for you to do that. The other way you can fund your account is if you have earned income, the IRS allows you to make an annual contribution. So for traditional and Roth IRAs, if you're under the age of 50 for 2024, you can put in $7,000. If you're over the age of 50, you have an additional $1,000 catch-up to where you can put in $8,000. For SEPs, simples, and solo 401ks, that's where you have the high contribution limits. So for example, for SEP IRAs, you can put up to $69,000, not to exceed 25% of your earned income. Same thing with the solo 401k, you have higher contribution limits where if you're under the age of 50, as long as you can show you have earned income from your business or side business, you can contribute up to $69,000. If you're over the age of 50, you have an additional $7,500 that you can put in. So again, those accounts allow you to put in high dollar amounts. For ESAs, you can put in $2,000 per year per child. For an HSA, again, having that high deductible plan. For individuals, you can put in $4,150, or for a family HSA plan, you can put in $8,300 for 2024. If you're over the age of 55, specifically for HSA, you can put in an additional $1,000. So just be mindful of that. The process with us is pretty straightforward. Once you've done your due diligence or if you've inquired with us in terms of consultation and you decide you want to proceed, the process is streamlined in 3 simple steps. Step 1, filling out our application to get your account open. You can do that directly on our website. You can also reach out to myself or one of my colleagues and we can walk you through the paperwork. We will assign you a dedicated account manager who works with you and any investment providers that you're working with or investing with. And then 2 is funding your account. So whether it's a combination of making an annual cash contribution from earned income, or you're transferring funds from an existing IRA or doing a rollover from an old employer plan like a TSP or 401k plan. And then 3rd, start investing. Is it going to be investing in real estate or investing in checkbook control using the LLC feature, or it's going to be precious metals, private placements? You essentially have a blank canvas. And with that, I'm going to go ahead and turn it over to our speaker.
Thank you so much, Reneika. It's just such a pleasure to be here. We've worked with Advanta in the past, and they are just a quality team, real specialists in the area of self-directed IRAs, and appreciate them introducing us and giving me some time to speak with you today. I love live events because they're so much more interactive. We can feel the crowd, we can get questions, and I'd love to make this as interactive as possible. So Reneika is going to be on the background a little bit, helping with those. We're going to talk about, of course, asset protection and estate planning are our priorities today, and in that order. So going to take a break after the first section, try to answer those questions. Then we're going to dive into estate planning, go through the content, and then answer those questions, and then whatever time available. Anderson, I'll introduce who I am and who Anderson is in the beginning here as we get going, but one of our key points of our business is education. In fact, Toby Mathis, one of our founding partners, has often used the term education firm over accounting firm or law firm or any other, because it's such a priority of what we do. So would love to have any and all of those questions. Want to make this more interactive and excited to dive in with everybody today. Okay, so I'm an attorney, which means, of course, the very first thing that I am going to do is give you a disclaimer. Sorry, can't resist, has to be done. As was mentioned, we do want to make these slides available for you. We do want to provide a lot of value for you. And so I'm not going to read the fine print to you, as exciting as that would be. But essentially, I'm giving general information today. I'm not representing you. I'm not giving personal advice. We love to do that. We love to connect. If there's anything that resonates with you, and we're gonna provide ways. Watch later on. We're going to provide ways for you to connect with us and get way more information that I'm able to provide in our 1-hour introduction here. But until that point, this is general information. These are stories. These are principles that then we want to take and tailor and personalize to you. Don't do the cookie cutter. Get it personalized later on. All right. Who is Anderson? Anderson Business Advisors. We've been around for 20, 30 years. We are the premier firm when it comes to asset protection and estate planning and tax planning. One of the reasons I love working here is that aspect of the one-stop shop. When you come to Anderson, you have access to the entire team, right? And we put together the legal side, the tax side, the estate planning side, the bookkeeping side, essentially everything that you need to really organize, structure, and protect yourself, we've got under one roof. Now, of course, if you just have one need, we're going to take care of that, right? We have lots of clients that come in needing all sorts of asset protection support, LLCs, corporations, the setup, the management, the compliance, etc. We'd love to help with that. But hey, you've been working with your CPA for the last 15, 20 years. We understand that. We can work with outside. But we've found that, oh, you save so much time, heartache, and money when all of those pieces are in-house, communicating with each other, with you in mind and goal. So that's what we do. We put together the tax planning, the asset protection, and the estate planning so we can make sure that you are protected, that your assets are preserved, and that you can prosper, focusing on what it is that you do best and letting us take care of the rest. As mentioned, we are an education firm. If you look up Anderson Business Advisors, if you look up, I've mentioned Toby Mathis, another of our founding partners is Clint Coons, and finally, Michael Bowman. We're on YouTube, we're on Facebook, I believe we're on TikTok now as well. And our goal is to get the information out there, right? Make sure you know what to do. You have the tools to protect yourself, to understand, to save on the tax filings, all of these benefits. If you want our help, we'd love to help, of course, but we want you to know. That's one thing that I feel that Anderson really sets themselves apart with, is we give you the knowledge and let you take and run with that as needed. My name is Jason Zundel. I am an attorney. I've been an attorney for a little bit more than a decade now, and I am a recovering litigator. And what that means is that before finding Anderson, I was the bulldog in the courtroom. I did small to mid-size businesses was my kind of priority, but we were a small firm, and so we did everything under the sun. Estate planning, family law, of course, litigation, mediation, arbitration. We got down and dirty with all of our clients, and the emphasis is a bit on that dirty part. So many times we'd finish a matter, we'd represent, we'd advocate firmly, fiercely even, and the judge would split the baby, or not sometimes, right? It's tough and it's expensive. And I just got so tired of seeing all of the different ways that it could have gone with just a little bit of foresight. And that's what brought me to Anderson, because that's what we do here, is we plan for the future so that when, unfortunately not if, in this litigious society, when the problems arise, you are protected. You have the tools, the plan, the structure in place that is going to set you up for success. Just really excited to dive in. So we're going to start with asset protection. When it comes to asset protection, separation is the name of the game. And of course, the classic imagery is eggs in a basket, right? If you put all of your eggs in one basket and you trip and you fall, that's the end of that, right? Eggs are very fragile, and your finances, as much as we hate to recognize it, your assets, your finances, your success can be very, very fragile. And so we want to make sure that it is separated and protected. When it comes to that, the tools of the trade for separation and asset protection are limited liability companies, LLCs is the standard acronym for those, corporations, and trusts. And these are tools that allow us to take ownership of your assets, of your business interests, of your investments, whatever it may be, and separate it out. Separate them from each other and separate them from you. Now, we're going to mention two other things on this point, is funding and timing. Funding referring to the importance of actually doing it. Oh, it's just scary how often it doesn't happen, right? When I say do it, I mean sign the documents, file them, do your corporate compliance, create bank accounts, make sure the assets are funded into, either assign the interest over, deed the property into it, right? Ensure that what you've actually set up functions, is funded, and the timing of it. Oh, this is a tough one. Now, as an attorney, I love to tell stories, and often I like to tell horror stories. They're more interesting, they're more, I don't want to say fun, but gripping, if you will. And this is one of those. I had a client recently, within the last 6 months, signed up with Anderson, did their due diligence, got really excited. I met with them for our initial consultation, getting on the phone, and start going through their assets, tailoring a plan, discussing. And towards the end of the conversation, he said, "Oh, Jason, I'm just so excited to be with you guys. I'm excited about getting this protection set up. I've got this lawsuit that was just filed against me, and I'm just really happy that we can move the rest of my assets into this structure and be protected." And let me tell you, just an immediate knife to the heart hearing that, because the timing is key. If litigation has already started, if a demand letter even has already been set out, it's too late. And I had to tell that to this client. I had to say, I'm very sorry to hear that. Unfortunately, what happens is that once a lawsuit has been filed, a court has supervision over the activities and the assets. And if you start moving assets out of your name, it looks like you're doing that deliberately to avoid any potential judgment or a creditor. That is what we like to call fraud. Fraudulent conveyance is the official term in most jurisdictions. And so by that point, it's too late. You have to ride that wave until either you've settled the case or a judgment has been issued and collected against before we can move any assets, before we can set up the structure and title your assets, separate those out and protect them. So timing is absolutely a key priority. We want to get this set up early. We want to get it set up properly and make sure that, this isn't the case, right? Get those eggs into their separate basket. And liability can come from a variety of sources, but it comes from assets that are inherently unsafe, right? So businesses can get sued, for professionals have malpractice. If you've got real estate, you can have trip and fall cases. You individually can be driving and maybe get a little distracted, or maybe you're coming home from the bar. Whatever the situation, liability can come from a variety of sources. And so we want to take that liability, each piece of the liability, and separate it out. And we want those assets of yours that aren't going to generate liability separate from yourself, because we just mentioned personal liability is the thing, and any of those other assets that can generate their own liability, right? Let's do a deeper dive though, because it's a common misconception. Well, I have an LLC, it's set up, I'm good to go, right? There's a little bit more to it, right? You need the proper build around the LLC, the operating agreement, keeping the corporate veil intact. Just on this one topic, we could spend hours and hours, but I wanted to mention the operating agreement specifically because it's one of the strongest additions to an LLC that will take your asset protection to the next level, right? And here are just 6 of many key provisions that are needed when it comes to the operating agreement and asset protection. Now, I highlighted number 3, charging order protection, right? Super important. Charging order protection ensures that a creditor can't go in and just force you to liquidate. What's the benefit of an LLC if they can just go in and say, yeah, well, you're the owner of the LLC, so we're going to go into that LLC and force you to sell or force you distribute to yourself, whom I have a judgment against, and I can take all that money. Why isn't this number one? Because not all states offer charging order protection as the sole remedy. So in those states that allow it, boy, is it important. And we want to make sure it is highlighted and hammered and all of the details in the operating agreement are put in so that you have the maximum charging order protection. But if you're in California, if you're in New York, charging order is not the sole remedy in those states and in many others. And so we need to look at the whole view for those operating agreements. Let's take a second and talk about pro rata distributions, right? Number 4, just as an example, when you own an LLC, you are the member, and so you can make contributions into the LLC or get distributions out of the LLC, get paid, right? It's your business, you have the right to pull. But when a creditor gets a judgment against you, when they have the right to collect it against you personally, but not your LLC, you don't want to make those distributions, right? And if you have partners, maybe they want to get distributions, but you don't. So it's very important to allow yourself non-prorated distributions in the operating agreement so that they can get payments and you don't have to. You can keep your investment in the LLC, continue to grow, develop, keep your capital account current, right? Make sure that's detailed within, but you're in control now. So many LLCs out there, even professionals and attorneys, they think that, hey, no, we want to be safe, we want to be protected, and so anytime there's a distribution, it has to be according to the percentage. That's going to protect me, right? It's going to make sure that I get my due. Wrong. You do that through the capital accounts. If you're forced to take pro-rata distributions and they're mandatory, it has to be distributed anytime anybody wants to take assets out. And it may allow a creditor to force this type of distribution to yourself and then collect against it. Whereas if you don't, you just leave it in the LLC. And yeah, they've got a judgment, but it's worthless piece of paper. They can't force you to pull any assets out. And so it puts you in the driver's seat for settlement. Let's come up with something that everybody can live with and go about our merry way, right? Gives you the power to negotiate and have that opportunity. So let's start putting the puzzle pieces together, right, for asset protection. We want the charging order protection. We want the separation. We want the protection. And this is what it looks like. Now you'll notice the holding LLC in the middle in blue there, that is our Wyoming holding LLC. We love Wyoming. It's got the trifecta. It's got charging order protection as the sole remedy, right? And just generally really good asset protection laws, statutes, and jurisprudence that support and benefit, that prioritize the small business owner, right? The landlord. It really puts you, the investor, puts you in the best possible light. The second reason we love Wyoming is anonymity. You can create an LLC in Wyoming and you don't have to publish the ownership. It doesn't go anywhere on public record. And so you can hold it and nobody will know that you hold it, which is a very powerful tool in asset protection. I'm going to give an example of this a little bit later on in my slides. And then the third leg of this stool is economics. It is very, very inexpensive to file and maintain entities in Wyoming, especially when compared to some of the other states that are known for charging order protection, that are known for asset protection, right? Nevada and Delaware, of course, being two of the top names, and honestly, two of the top states in the United States for setting up LLCs and for asset protection. But they are hundreds of dollars per year per entity to set up and maintain. Now, Wyoming did increase their prices this last year, the year before, fairly recently. It is now $62 per year instead of $60 per year for filing. So a very reasonable state, great place to set up your holding LLC, which is going to be kind of the backbone. Now, why the different other LLCs though? Separation, right? This is assuming maybe we have, maybe we live and operate a business out of Utah. We have property in Indiana, and we have land, undeveloped land in Texas. Now, we are here today with Advanta. We're focused on IRAs and investments. And so even the business in Utah, it's got to be passive, right? We don't want to run into UBIT, sorry, space a little bit, but we don't want to have active income coming into our retirement accounts and get extra taxation, even higher than if you'd run it in your own name. So passive business, but a different source of income, a different area of risk. And so we want each of those separated out into their own LLCs, so that if there's a fire at the rental home in Indiana and liability associated with that, the only risk of loss is that property in Indiana. Now, let's imagine the normal scenario, honestly. All of this, your property in Indiana, the passive business that's generating, that you've invested in Utah, the land in Texas, it's all just directly owned, not by a Wyoming LLC, but directly owned by you, by your self-directed IRA. That fire in Indiana means that the plaintiff attorney can go after all of those assets to collect on any judgment that is awarded. This separation into the individual LLCs, this is what allows us to ensure that, again, there's still a fire. Problems happen. There are issues, difficulties, all of these things. But now it can only attach to that property in Indiana. In fact, let's take a look at the view of the plaintiff attorney. That's all they see. Because the Wyoming LLC is held anonymously. They don't know you. They don't know your IRA. They don't know what else you're investing in. All that plaintiff attorney sees is this property is owned by an Indiana LLC, which lists a Wyoming LLC. And that's going to tell that attorney a couple of very important things. Number one, it means that you're a sophisticated investor. You are well set up. And with not just an Indiana LLC, but a Wyoming LLC, you are professionally set up. You are prepared. And can I give you well, I can't call it a secret anymore. It's just kind of out there. Attorneys, especially injury attorneys and plaintiffs attorneys, they're lazy. They're lazy and they're greedy. And so they want to maximize their income, because very often they're working on contingency. They're not working on hourly, at least not until they see this. As soon as they see this, they tell the client, hey, we need to settle for insurance, because for any chance to even find out who is behind the structure, much less what else they have, we have to prove commingling. We have to go through intense discovery. We're going to be spending hours and hours and hours of work and labor just to see if there's more to find here, just to see if there are extra assets that we can pursue, that we can go after. It's not worth it. Let's settle for the insurance proceeds. Let's everybody move on with their life. Powerful tools here, powerful principles for asset protection, for protecting yourself because of the anonymity, the charging order protection, and the separation, that fire that could have wiped out so much of what you've developed, what you've invested in, even within your IRA, right? It doesn't have to be in your personal name. Within your IRA, not every state protects it. There are ways to get in after those assets. Take the right steps and protect it. And these LLCs provide that. Now, let's imagine you have personal liability. And watch this, because this next slide is one of my very favorites. This is what the plaintiff attorney would see if they're trying to go after you and your IRA. Nothing. They do their research. They use all of their tools and their private investigators and their LexisNexis to pull up everything you've got. And if you're properly structured, that's what they see. They see that you have an IRA. And that's it. Because all of the actual assets within the IRA are properly structured and housed within a Wyoming LLC that is anonymous, right? Very, very powerful tool. One of my favorite stories to tell on this topic is, it's not my story. This one comes directly from Clint Coons. He had a couple of clients out of California, actually. We're picking on California a little bit, but they're land developers, they're investors, and they just got saddled with the wrong project, right? They got involved, and if it could go wrong, it went wrong. Boy, Murphy's Law was just in powerful effect here. So liability, lawsuits one way or another, everybody and their dogs has been incorporated in. Our client and his father were both invested into this, and it's important to note two things. Number one, our client actually had a higher net worth than his father at this stage, but had been our client for years at this point. That timing couldn't be better and was very well structured. So the son goes in first, our client, goes into a discovery meeting, into a settlement meeting, kind of the initial get involved with the plaintiff's attorneys that were trying to put the whole puzzle together. The entire meeting lasted about 45 minutes. They asked him a few questions specifically to what had happened and what his direct involvement was, and then offered him a very reasonable settlement amount based on that involvement to just walk away and be done, to be a neutral fact witness should they need to be involved later on in the process, but no longer a party to the case. Oh, just huge weight off the shoulders. Very surprising, but excellent experience. Tells his dad about it. Dad goes in the next week or so for his, and just gets hammered. 6 hours for that initial meeting alone with the father, going over every detail of his involvement, of his company, of him personally, of his assets. And just by the end of this, he's exhausted, he's stressed, he's furious, because especially when you go in with unmet expectations, is like, and finally he says to the attorney, hey, what's going on here? You let my son out with 45 minutes of general talk. This is ridiculous. And the attorney looks at him and says, well, your son doesn't have anything worth going after. You do. We did our homework. You've got assets galore. You've got this property, you've got that business, and if we can stick this to you, we've got plenty to collect against. Because they couldn't find the son's assets. They looked at him and they saw nothing. That's the power of anonymity. And whether you're investing individually, whether you're investing through your IRA, the principle absolutely applies. Separate your assets, utilize anonymity, and protect yourself so that when something comes up, you are in the best possible position to just move on with your life. Resolve it, get a settlement, utilize insurance, but then move on and not have it permanently or significantly affect what you've worked so hard to build up for. Oh, love that story. And just very passionate about tailoring this to you, sitting down one-on-one with you, finding out where you're investing, how you're investing, what should your structure look like, because every single one is going to be different, it's going to be tailored, and we're going to focus on you. Okay, Reneika, thank you. We're towards the end of our discussion on asset protection, a good pausing point. Are there any specific questions that I can help with or that have been submitted with regards to asset protection?
Yes, and great information. There's some questions. Just bear with me. It says, someone who's a very experienced investor told me to put everything into a trust and not an LLC. Why does Anderson advise clients to put real estate into an LLC?
Oh, this is a fabulous question. And I'm going to approach it from two perspectives. The first one is we absolutely encourage utilizing trust. You'll notice that was one of the key tools of the trade, especially a living trust, which is the asset protection that we're talking about next. So I'll leave that a little bit. We're definitely going to get to that. But the second perspective, a common misconception is that a living trust, a revocable grantor trust, does not provide asset protection. A very important tool. I encourage every client, and I'm an attorney, I can't do absolutes, almost every client to utilize a good living trust. And we regularly implement land trusts and personal property trusts for maximum flexibility and anonymity. But the trust itself does not provide asset protection. It does not provide separation. Because you, as the grantor, the creator of the trust, can change it, can amend it, can move assets in and out, it is not considered a separate entity. And so you don't get that charging order protection, you don't get any separation, and a creditor can go in and invade the body, take the assets of a trust if it's attached directly to you and not to an LLC. Now, if you're utilizing irrevocable trusts, which are much less flexible, but they're irrevocable. Once you set it, you're locked in stone. That can provide asset protection. Personally, for most clients, an LLC is going to offer more flexibility and a very similar level of protection, and so I prefer that route. But there are absolutely situations where an irrevocable trust, an asset protection trust, something to that effect is going to be a very powerful tool. Great questions. Great question. Okay. Others.
More questions. It says, talking about separation of assets and creating different LLCs, how far do we go on separation? Put every different property in a different LLC? If not, what is the best way to go about this? If not, what is the best way to go about it?
A sophisticated question, but one that's going to trigger just the stereotypical attorney answer. It depends. Now, good, better, best, your best protection is going to come by separating every high value asset, especially every high value that has risk. So we do say, and one of our mantras is one LLC per property for the majority of investors, because each property, each of those is an investment. Each of those is a check coming in from the mail, and we want each of them protected and separated. That being said, I have clients that have hundreds of properties. That's a lot of LLCs to juggle and manage and take care of. And so depending on your risk tolerance, some of them decide, hey, up to $1 million worth of assets in one LLC. And then we're going to separate and utilize different. Another important thing to consider is the risk, the liability potential for each asset, right? If you've got just virgin land, right, acres and acres of land in Montana, in Wyoming, in Texas, nobody's there. There's a relatively low likelihood of liability there, of accident, of a risk to you. And so combining that into one LLC, probably not a big issue, something that you can absolutely do. So it's going to depend on your risk tolerance a little bit, but ideally, each stream of business, so active business or passive, each separate stream of income should be in its own LLC. And that applies to real estate as well. If you're generating income, generating rents from a property, it should probably be in its own LLC. Very good. Let's do one more right now, and then we'll shift into estate planning and hopefully be able to come back and address some of the others.
Okay, let me answer one or two related to Advanta, and then we can certainly
For sure.
over. Okay, it says, how much do you all charge for IRA LLC checkbook control account, both setup fee and annual ongoing fee? So there's Advanta related fees, but just know we don't set up LLCs for our client. You can certainly use Anderson Business Advisors to set the LLC portion up. But in terms of your account maintenance with us, we're not the highest in the industry, we're not the lowest. Our focus is that quality service. There's 3 core fees, and you can certainly look at our application that outlines all of our, the fees related, but just the 3 main fees typically is the opening fee of $50, the transaction fee when you make an investment, so either $95 or $145, depending on what you're investing in. And then if you're doing checkbook control LLC, it's an annual fee with us for a flat fee of $295 for that LLC asset. That's the core fee related to your account. But in terms of setting up the LLC with your state or Wyoming, you definitely use a legal service such as Anderson to help with that. Question related to you, Jason. It says, is it better to have brokerage accounts in Wyoming LLC or in your state you live in?
Ooh, I strongly prefer brokerage accounts be in the Wyoming LLC because it's a legitimate business interest, and so you can put it in an LLC. You don't want to mix personal, right? You don't want to put your checking account, for example, that you use for your day-to-day expenses in a Wyoming LLC. But a brokerage account is an investment. Wealth management is absolutely a very common industry and business. And so you put that in a Wyoming LLC, so long as you are not paying yourself a salary, right? When you pay yourself a salary, that's a trigger for utilizing the state where you're located. For example, an S corporation, if you've got that type of setup, that needs to be in an entity that's not tied to your Wyoming LLC, that is in your state, because it requires a W-2 salary. But for a brokerage, you can take distributions to yourself rather than salary, and you can set that up in the Wyoming LLC for very strong asset protection and anonymity.
Okay, I'll ask one more question, then we can go to the next slide. I think you mentioned where you're located, your headquarters. This question is there one of your Anderson Advisors offices located in Gainesville, Georgia? And it lists a number. Like, I know you guys are located on the West Coast, but do you have an office in Georgia? That's what they're asking.
We don't have specific offices in Georgia. Nope, we've got Nevada and Washington and Utah and Texas right now for physical offices. That being said, we offer services in all 50 states. We don't do foreign law currently. We don't set up entities outside of the 50 United States at this time, or do tax preparation for foreign taxes and filings. But all 50 states we work in, we have the proper licenses, the attorneys, the CPAs, et cetera, to operate in all 50 states.
Wonderful. Thank you so much, Jason. You can proceed.
All right, let's dive in. Great questions. I love to make this more interactive. One of the things that I'm going to offer to Advanta, to those that are participating in this webinar, is a free link to one of Anderson's tax and asset protection, like full webinars. We're talking 6 to 8 hours of information. Usually you need to go through channels and there's either payment or involvement as a client. We're going to give you a free link. So you sign up through this link, it's free. And not only is it just way more information than, of course, I've got an hour with you. So it's way more information. It goes deep, not into asset protection and estate planning, but also tax planning and some of the powerful tools that you can utilize. For example, having a corporation sponsor your IRA so that you can make contributions and those can be matched by your corporation and be deductible to your active income. Just some amazing tax strategies that we go through in that webinar. But also we have much more staff involved. We have attorneys and CPAs. So all of these types of questions that you've got, you can get them answered privately, individually, through our team there. So just a really cool resource. Watch for that link towards the end of our conversation today. All right, let's take a look at estate planning. And we had that awesome question earlier on trusts and the utilization of trusts. This is one key area that every sophisticated investor will have, is a good estate plan, usually in the form of a living trust, and not just the trust, but an estate plan portfolio. So the trust with the various ancillary documents, pour over will, powers of attorney, HIPAA waivers, advanced care directives, right? All of these documents that put together an estate plan. Now, why is this so important? I'm sorry, I can't resist. I love this imagery because it's so true. And it's not just true, but it brings up that important principle of you can't take it with you, but you can really do some good with it, right? You've spent your whole life learning, studying, investing, growing, blood, sweat, and tears to get yourself where you are today. And do you want to just let some judge decide what happens with it next? Somebody that you've never met, somebody that, well, depending on the attorney that you talk to, somebody that's generally a good person, these judges, but doesn't know your family from Adam, they're going to make all the decisions? No. A good estate plan is going to put you in the driver's seat. It's going to make sure that your family, when, how, and why you want, gets control and access to your assets, that they get it immediately, and that they avoid the ever dreaded probate, right? You can't take it with you, but you can make the process so much smoother and easier and instantaneous for your family. And I promise you, they will be so grateful for that. It's kind of a tough conversation area. We're talking about death, we're talking about disability. They're heavy topics, but it makes such a difference when it's done properly. Can't tell you how many times family members have come in and just been so grateful and then set it up themselves because either they've seen the alternative or they saw how smooth it went when properly done. So let's talk about the different types of estate planning that you'll see in the different options. Dying intestate, right? First one on the top here, that is a legal term of art for doing nothing, right? You didn't have a will, you didn't have a trust, you didn't do any advanced planning, and so just no's across the board. You don't decide who is the guardian of any minor children that you have or are responsible for. Absolutely, the entire estate is going to be subject to probate. It's going to be very expensive. It's going to be time consuming. You don't have any say in who it goes to or where or how. Avoids disinheritance of children. Why is this its own specific one? Because it's ugly and it's more common than you think. And just with the life and the trends, it's only increasing in regularity, in occurrence. And so what I mean by that is, for example, if you and your spouse, you're married, you have your children, life is great, you're setting things up, something happens to you, you pass on. Your spouse gets remarried, they pass on. Well, the law says the spouse gets at least half, sometimes everything. And so your children, at best, get half of the assets, whereas the new spouse, if no planning has been done, again, at minimum, gets half of everything that you've worked to develop. And so unintentionally, you've just disinherited your children because there was no plan in place. And the law goes to the traditional family. It's designed around that traditional nuclear family. And any change to that, right, it's a little bit archaic, absolutely, but you have the ability through a proper estate plan to make sure that doesn't happen. Dying intestate, doing nothing, doesn't get around that at all. Joint tenancy, and specifically that acronym that you'll see, joint tenancy with right of survivorship, does not control guardianship, does not control how it's distributed. As soon as you die, whoever you've listed on title with you, which is how a joint tenancy works, gets immediate access to it, whether that person is 18 or 7 or 89, immediate access. It does avoid probate, so it's a tool that can absolutely be used, but alone, not sufficient. A will, same principle applies. And now this is surprising to many because, hey, a will, that's, lots of attorneys are still advertising and utilizing wills. Why is it such a bad option? Because a will is a loss leader. See probate, right? If you have a will, you can decide who gets your assets. You don't decide when, but you decide who, and everything else is subject to probate. And even that, a judge has a little bit of more leeway than I would like. Whereas a living trust, just the clear answer, yes, down the board. You're in charge of who takes care of your children, of who manages your estate, of when your children get access to the funds. Personally, I was a super responsible 18-year-old kid. I was already starting college. I had scholarships set up. I'd even graduated high school with my 2-year degree, my associate's degree. I mean, of course, I can't take any credit for that. I have amazing parents. I was 18. I was not ready to be in charge of anything except what I absolutely had to. Making it to class, my part-time job, and learning what it means to be an adult, right? So you get to decide how and when, and you ensure that no matter what happens in the future, your children are provided for, right? Remarriage, not. Once you've made your living trust, it becomes locked in for your children and your family. Very strong. No, I probably don't need it. I don't have that big of a estate. It's not really involved. So much more involved than you think, and especially for those interested here, those working with Advanta, those that are, I mean, you're here learning and growing and developing your knowledge on a Tuesday morning, a Tuesday afternoon, depending where you're at. You've got an estate, so especially your retirement assets and your business interests, right? As you start to look at things, it really adds up. An estate can be large, can be very important to plan and prepare. Now, my next slide is ugly because the process is ugly. Probably my #1 reason for just imploring clients to set up a good estate plan is you completely avoid probate. That image, it grosses me out every time I see it, but I have to use it because that's what probate is about. Common misconception, again, probate is not set up for you and for your assets. Probate is set up so that your creditors, specifically the #1 creditor of all US citizens, the IRS, taxes, so that your creditors are paid. Very time consuming, very expensive. This is a multi-billion-dollar industry, and the average time for a probate case is 2 years. And your family doesn't get access, doesn't get control until well along that process, sometimes the finalization of it. Here's that lost leader conversation. It's expensive, it's complicated, it's public. And so the attorney says, no, I'll do it cheap. Here's a will for you. You're set up. $500. Easy. But their name is on that will and you worked with them. And so, yeah, have my family call them up and do probate for us. And there's the thousands and thousands of dollars that the attorney is going to earn on your assets taking your family through probate. Don't do it. I know there's every excuse in the book, right? I've heard them all. I've seen them all. It's not worth it. And Anderson especially, we do fixed pricing so that you know exactly what you're going to pay and you're not going to ever get nickeled and dimed. We make things simple. We focus on you. We're very approachable. We take away the complication, the uncomfortableness, the heaviness. We've seen it all. Nothing you have is weirder than what we've already done, right? And I'm one of the ones that do it. So I'm going to have that personal conversation with you. I'm going to get to know you. I'm going to tailor this to you so that you can make sure your family is protected, that your family is provided for, that you, who have spent all the time building your assets, teaching your children, growing your family, can decide when and how and who is going to help your family continue that process so that generationally the wealth is developed and grown and protected. Clearly just so passionate about it. I see that our time is just about ended. I want to thank everybody so much for joining us today, for being part of it. I have a little bit of flexibility. I know that I want to respect your time, and so if you've got to go, I want to thank you. We've got that link. The way that we're thanking you, please come join us. Again, we have these, this link. I'm going to put it in the chat as well, so that Reneika can pass it on to each of you. It gets you free access to our attorneys, to our CPAs, to, again, 6+ hours of detailed strategies, knowledge, information, and personalization to our team so that we can help with this. So would love to see you all there, would love to help further develop and manage this process for you. Reneika and her team are going to do an amazing job with your investments and your IRA. And we'd love to be part of her team helping to then protect and ensure that your family gets the full benefit of all of those. Okay, again, if you've got to go, I totally understand. I have about 5 minutes leeway. I'd love to answer some of your other questions, or I'd love to see you at our event so that every single one of your answers of your questions is answered individually by one of our attorneys or CPAs. Go ahead.
Thank you so much, Jason. Great information, great participation. I do have like 1 or 2 questions I'll have you answer for the remaining questions. I'm happy to reach out to you directly to get those answered for you relating to IRAs. The question is there any other way to capture the current estate tax limit other than moving assets to irrevocable trust before end of next year?
Ooh, this is a tricky question. It's a really good one, but it's a tricky question. A key principle of law and tax, especially at Anderson, is prepare and look towards the future, but plan for the now. Right now, we have that great estate tax exemption that is what we're at, 13 million per individual. That's doubled for a married couple filing jointly. We plan as though that's the case. If that's changed, right, we're in the middle of a voting cycle, we're in the middle of so much uncertainty and upheaval in many aspects, but especially in fiscal and financial laws and changes. If that changes, then we will adjust the strategy. But for now, plan according to that, because we've had clients pull the trigger prematurely in previous voting cycles thinking, hey, there's no way this large estate exemption is going to last. They put it in irrevocable trust and end up getting hammered by taxes and unnecessary taxes because it didn't actually change. To the core question though, irrevocable trusts really are the way to go if you are getting extended beyond that estate tax exemption. Yes, whether it be an ILIT, an irrevocable life insurance trust, an asset protection trust, right? And a defective grantor irrevocable trust, intentionally defective, right? And all of these different tools are the best way. Now, again, going back to my initial disclaimer, I want to talk to you. I want to sit down with you, see what your assets are, see where your income is coming from, and tailor that to you. But yes, irrevocable trusts are the best ways to avoid that. You can build in corporations. There are some pros and cons, though. That's the individual conversation I'd like to have.
Oh, wonderful. Last question for Jason. It says, what if no will, but most assets are IRA 401k with beneficiaries? Does the IRA 401k stuff with beneficiaries have to go through probate? I've been told they don't have to go through probate. So if you list a beneficiary, then automatically, I do know, like, it goes directly to whoever the named beneficiary is. But Jason, feel free to add or clarify.
No, it's a great point, especially for this group, right? Working with Advanta, IRAs and 401ks, IRAs especially, are a preferred and a priority retirement investment. And Reneika, you're exactly right. If you properly designate the beneficiaries on your retirement accounts, it will go directly to that beneficiary and avoid probate. Love it. Now,
wonderful.
I got to put one quick disclaimer though. What if something happens to them? What if they've predeceased you? There's so many things that can happen. And so I would still, even if your main investment vehicle is retirement account, is self-directed IRA, get the living trust. Have that be part of it. Because number one, you don't know what's going to happen. And if your specific beneficiaries are gone and your grandchildren are the one that receive it, they're not listed as beneficiaries. Your children are. And so it would go through probate under those circumstances, but also the timing, right? If your children are younger, if your children have special needs, if your beneficiaries are like that, a trust is going to help to manage that process of when and how they receive the funds versus just an immediate, oh, here you go, good luck. Great question though, yep.
Okay, and that's the end of the presentation. I did add the link. I know someone referenced that they're unable to access it. I did reply back directly to you with the link, so click on it, but no worries, I have it. I have Jason's presentation as well, so feel free to reach out to me. Again, Jason, thank you so much for the wealth of knowledge. Thank you everyone for participating, your questions, great questions, and happy investing.